My name is Ilara Whitcomb. I'm 29 years old, and 3 weeks ago I stood in probate court in Maricopa County while my father pointed at me and shouted, "She is mentally incompetent. She's an embarrassment to this family." His voice echoed against the varnished wood panels. I could smell the sharp polish on the courtroom benches, feel the air conditioning drying the back of my throat. My mother didn't look at me. She kept her chin lifted like we were at a charity gala instead of a hearing to strip me of my legal rights as an adult. I didn't cry. I didn't defend myself. I just sat there, hands folded in my lap. Then the judge leaned forward. "Mr. Whitcomb," she said slowly, "do you actually know who your daughter is?" Their attorney froze. My father's face lost color so quickly it was almost clinical. He didn't know. That was the problem. Before I tell you what the judge had in front of her that morning and why my parents' entire strategy collapsed in under 10 minutes, take a second to like and subscribe, but only if you believe silence can be stronger than shouting. And tell me in the comments if your own parents tried to declare you mentally incompetent, would you fight loudly? Or wait, I grew up in a house where image mattered more than truth. Our place in North Scottsdale sat behind a stone gate with a keypad and a bronze plaque that read, "Whitcomb Holdings," in understated serif letters like we were an institution instead of a family. The air inside always smelled faintly of citrus cleaner and something floral. My mother favored gardenia, I think. It was the kind of house where furniture wasn't meant to be leaned on and conversations weren't meant to go too deep. From the outside, we looked stable. My father, Douglas Whitcomb, built resort-style condominium projects across Arizona during the post-recession rebound. He liked to remind people that he had an instinct for land. My mother chaired 2 nonprofit boards and hosted fundraising dinners where crystal glasses chimed and everyone laughed a little too loudly at my father's stories. I was the only child. You would think that would make me central. It didn't. In our house, I was the variable, the unpredictable one, the sensitive one. When I was 11, I cried during a dinner party because I overheard my father tell an investor that emotions are liabilities in business. He said it while glancing at me. Later that night, he stood in my doorway and said almost conversationally, "If you can't control yourself, Ilara, you'll never be trusted with anything serious." He didn't raise his voice. He never had to. The temperature of his disappointment was enough. By high school, the narrative had shifted from sensitive to unstable. If I disagreed with him about a project or asked why certain numbers didn't reconcile in the company's annual report, I was overreacting. If I locked myself in my room after an argument, I was spiraling. Words like erratic and dramatic floated through our kitchen as casually as steam from my mother's tea kettle. The irony is that numbers were the only thing that ever made sense to me. I liked balance sheets because they told the truth whether you wanted them to or not. Assets equaled liabilities plus equity. It was clean. It was fair. No one could gaslight a spreadsheet. I studied accounting at Arizona State University. My father paid tuition, but not without reminding me that I wasn't leadership material and that I would probably end up doing back-office cleanup for someone smarter. I graduated near the top of my class and passed the CPA exam on the first attempt. When I showed him my license, he said, "Good. At least you'll be useful." Useful. Not capable. Not impressive. Useful. The 34% stake in Whitcomb Holdings came from my grandmother, my father's mother. She transferred the shares into a trust when I turned 25. It was structured carefully under Arizona trust law, with me as the beneficiary and voting rights attached once I reached a specified age. My father framed it as a sentimental gesture. "Your grandmother always had a soft spot for you," he said like it was charity. What he didn't expect was that I would actually read the operating agreements. As a minority shareholder with 34%, I didn't control the company, but I had access rights. I had the right to inspect certain records. I had the right to question transactions that materially affected shareholder value. When I started asking about a land acquisition outside Flagstaff that was leveraged at an aggressive loan-to-value ratio, my father's tone shifted from indulgent to irritated. "You don't understand development," he told me one evening in his office. The blinds were half closed, casting narrow stripes of light across the mahogany desk. "You see numbers. I see opportunity. I see debt servicing risk at current interest rates," I replied. He leaned back in his chair and looked at me like I had confirmed something disappointing. "This is exactly what I mean. You fixate. You catastrophize. It's not healthy." That word again. Healthy? At home, my mother started suggesting therapy. Not in a concerned way, in a strategic way. "It would help your father feel reassured," she said over breakfast one morning, spreading almond butter on toast with precise strokes. "Investors watch family stability. You've been intense lately." Intense meant I had requested detailed financial statements. Intense meant I asked why certain vendor contracts were awarded to a company partially owned by one of my father's golf partners. Intense meant I refused to sign off blindly. The first time I heard the phrase mental capacity attached to my name, it wasn't in a courtroom. It was in our living room. My father was on the phone, pacing near the fireplace. He didn't realize I was standing in the hallway. "If she keeps pushing like this," he said, voice low but sharp, "we may need to explore options. I won't have instability jeopardizing 40 years of work." Instability. Options. That night, the house felt colder than usual. The air conditioning hummed steadily, and I lay awake staring at the ceiling, listening to it cycle on and off. I told myself I was being paranoid. Parents don't move against their own children over boardroom disagreements. Not in real life. But over the next 6 months, small things began to shift. I was excluded from informal strategy meetings. Emails that once included me suddenly didn't. When I requested documents through formal channels, responses were delayed. My father began telling mutual acquaintances that I was under a lot of stress and struggling with what no one specified. The final fracture came when I declined to approve a refinancing structure that would have diluted my voting power through a new class of preferred shares. I cited Arizona corporate statutes and the operating agreement. I did it calmly. I did it in writing. 2 weeks later, I was served with papers at my condo in downtown Scottsdale. Petition for appointment of guardian for an adult, filed by Douglas and Marlene Whitcomb. Grounds: alleged mental incompetence, impaired judgment, inability to manage financial affairs. I remember the smell of the hallway carpet outside my unit, clean, but synthetic like heated plastic. I remember the process server's neutral expression. I remember my hands not shaking. That was the strangest part. For years, they had built a quiet narrative about me. Too emotional, too intense, too unstable. I had dismissed it as family rhetoric. I didn't realize they were documenting it. The petition was 32 pages long. I read it twice the night it was served, sitting at my kitchen island with a single recessed light on above me. Outside my window, Scottsdale traffic moved in soft ribbons of red and white. Inside, it was just me and the steady hum of my refrigerator. They described me as financially reckless. They cited my obsessive fixation on minor accounting discrepancies. They referenced emotional volatility during shareholder discussions. There were even timestamps of emails I had sent questioning debt exposure ratios framed as evidence of agitation. It was meticulous. That was what unsettled me. Under Arizona Revised Statute Section 14-5303, to appoint a guardian for an adult, the court must find clear and convincing evidence that the person lacks sufficient understanding or capacity to make or communicate responsible decisions. My parents weren't just calling me dramatic, they were asking a judge to remove my legal autonomy. Buried halfway through the filing was a request for temporary emergency guardianship pending full evaluation. That would have allowed them to suspend my voting rights immediately, to step in for my protection. For my protection. I set the papers down and walked to the sink. The water ran cold over my hands longer than necessary. I watched it swirl into the drain and felt something inside me go very still. I didn't call them. I didn't text. I didn't drive to their house and demand an explanation. I opened my laptop instead. The next morning, I contacted a probate litigation attorney in Phoenix, whose name I had seen cited in a continuing education seminar. Her office overlooked Camelback Mountain. When I sat across from her in a conference room with glass walls and neutral carpeting, she didn't offer sympathy. She asked for documents. "Have you ever been diagnosed with a cognitive impairment?" she asked. "No." "Hospitalizations, psychiatric holds?" "No." "Any documented history that could support this?" "Only disagreements," I said. She nodded once. "Then this is either about control or money." "Possibly both." We discussed the court process. The judge would likely appoint an independent evaluator, a forensic psychiatrist, to assess my capacity. My parents would have to present evidence. So would I. The standard was high, but so were the stakes. Even a temporary order could damage my professional reputation as a CPA. "Do you want to settle?" she asked. The question lingered between us. Settling would mean negotiating some form of financial oversight, a monitored account, a voluntary conservatorship arrangement. It would be quiet, contained. It would also mean validating their narrative. "No," I said. My voice was steady. "We respond formally." Within days, my attorney filed an objection. We requested strict evidentiary standards and opposed any emergency guardianship absent medical proof. I also notified the 2 investment firms I consulted for preemptively calmly explaining that a family dispute had escalated into litigation, but that there were no findings against me. Both firms replied the same way. "Let us know if you need character references." My parents, meanwhile, escalated. I received an email from my father late one evening. Subject line: "We tried to help you." "You're not well," he wrote. "This isn't punishment. It's intervention. You've been unraveling for years and everyone sees it but you." Everyone. I stared at that word for a long time. It's powerful the way people weaponize consensus. If everyone believes something about you, maybe it becomes true. Except in court, everyone isn't evidence. 2 weeks later, the court appointed Dr. Lucas Kincaid, a forensic psychiatrist with experience in capacity evaluations. I looked him up that night. Board certified, frequently retained in complex probate disputes, known for thorough reports. My mother called the morning after the appointment order was entered. I let it go to voicemail. "Ilara," she said, voice smooth but strained, "you can still stop this. Just cooperate. Show the judge you're willing to accept guidance. This doesn't have to be humiliating." Humiliating. That word landed differently. They weren't afraid I was incompetent. They were afraid I was independent. And if they were willing to argue in open court that I lacked mental capacity, then they had already crossed a line that couldn't be uncrossed. I printed the petition again and placed it in a folder labeled simply "Evidence." Not because it proved I was unstable, because it proved exactly who they were willing to say I was. The evaluation with Dr. Lucas Kincaid took place in a low-rise medical building near downtown Phoenix, not far from the federal courthouse. The waiting room smelled faintly of disinfectant and burnt coffee. There were framed diplomas on the wall and a muted television playing a daytime news cycle no one was watching. I arrived 15 minutes early, not because I was anxious, but because punctuality is a habit you build when you grow up being told you're unreliable. When he called my name, his voice was neutral. He didn't smile too much. He didn't frown. He shook my hand once and gestured toward his office. It was spare 2 armchairs, a desk, a legal pad, shelves of thick psychiatric reference books. No family photos, no softening touches. "I've reviewed the petition," he said after we sat down. Today isn't about your parents' opinion. It's about functional capacity. I'll ask direct questions. Understood, I replied. He began with orientation questions, date, location, current events. Then memory recall, serial subtraction, abstract reasoning. It felt clinical, almost mechanical. I answered without defensiveness. Years of being mischaracterized had trained me not to over-explain. After about 40 minutes, he shifted. Tell me about your involvement in Whitcomb Holdings, he said. So I did. I described the capital stack on the Flagstaff acquisition. I walked through projected cash flows under varying interest rate environments. I explained why introducing a new class of preferred shares would dilute minority voting power without proportionate protection. I referenced specific sections of the operating agreement from memory. He didn't interrupt, he just wrote. At one point, he looked up. You're aware this evaluation could determine whether someone else is granted authority over your financial and personal decisions. Yes. And how do you feel about that possibility? I paused. Not because I didn't know, but because I wanted to be precise. I feel concerned about misuse of the guardianship system, I said. It's designed to protect vulnerable adults. If it's used strategically in shareholder disputes, that undermines the statute. He held my gaze for a moment longer than before. The evaluation lasted nearly 3 hours. When I left the building, the Arizona sun felt sharp against my skin. The parking lot shimmered with heat. I sat in my car with the engine off and let the silence settle. I didn't know what he would conclude, but I knew I had shown up as myself. Not reactive, not defensive, just factual. While the medical evaluation unfolded, I began building something else quietly. Through formal inspection rights as a shareholder, I requested internal communications regarding the proposed refinancing and preferred share issuance. My attorney sent the demand letter citing the relevant provisions under Arizona corporate law. This time, they couldn't ignore it without risking a separate breach claim. The documents came in batches, PDFs with metadata, email chains, draft term sheets. One thread stopped me. It was between my father and our outside counsel. The subject line read, Capacity Strategy. I read it 3 times before the words felt real. If Ilara continues obstructing the recapitalization my father had written months earlier, we may need to explore incapacity proceedings. Temporary guardianship would neutralize voting complications. Neutralize. As if I were a malfunctioning component. The attorney's reply was cautious but not dismissive. He referenced the high evidentiary burden and potential reputational risks, but did not discourage the idea outright. Instead, he suggested documenting behavioral irregularities. Behavioral irregularities, emails questioning debt ratios, requests for compliance documentation, written objections to dilution mechanisms. I printed that thread and placed it in the same folder as the petition. This wasn't about my mental health. It was about timing, about leverage, about ensuring the recapitalization passed without a dissenting vote. The turning point wasn't dramatic. There was no shouting, no confrontation in a marble foyer. It was the slow realization that I wasn't being misunderstood. I was being managed. A week later, my attorney received notice that Dr. Kincaid's preliminary findings would be submitted directly to the court under seal. Neither side would see the full report before the hearing. That detail unsettled my parents more than it did me. I knew because my mother texted for the first time in days. "This has gone too far," she wrote. "You're forcing strangers into private family matters." Strangers. They had filed in public court. They had accused me in writing of lacking the capacity to function as an adult. But now the presence of an independent psychiatrist felt invasive to them. I didn't respond. Instead, I prepared an affidavit outlining my education, licensure, professional engagements, and prior experience serving as a financial consultant in federal bankruptcy proceedings. I attached copies of my CPA license, continuing education records, and letters from 2 managing partners at firms I advised. not character endorsements, competency, confirmations. The night before the hearing, I couldn't sleep. Not from fear, from clarity. I lay in my condo bedroom listening to the faint hum of traffic from Scottsdale Road 3 floors below. The ceiling fan rotated in slow, even circles. I thought about every time my father had described me as unstable, every time my mother had suggested I was too much. They had been building a story about me for years. Tomorrow it would collide with documentation. I didn't need to win emotionally. I didn't need them to apologize. I needed the record to reflect reality. And somewhere inside me, beneath the restraint and the measured breathing, something steadied into place. If they wanted the court to decide who I was, then the court would have all the information. Not just their version, mine. Before I tell you what happened when the judge opened Dr. Kincaid's sealed report and my father decided to speak out of turn, I need to ask you something. If the people who raised you tried to legally erase your independence, would you defend yourself loudly or let the evidence speak? If this story feels uncomfortably real, take a second to like and subscribe. Not for drama, for clarity. And tell me, have you ever been labeled unstable simply because you refused to stay quiet? The hearing was scheduled for 9:30 a.m. in a probate courtroom on the 3rd floor of the Maricopa County Superior Court building. The hallway outside was quieter than I expected. No dramatic confrontations, no whispered apologies. Just the muted shuffle of attorneys reviewing files and the faint echo of footsteps against polished tile. My father stood near a window with Trent Halverson, their probate attorney. He wore a navy suit tailored too precisely to be casual. My mother stood beside him, posture immaculate, hands clasped around a leather folder as if she were attending a board meeting instead of asking a judge to remove her daughter's autonomy. Neither of them approached me. I sat with my attorney reviewing nothing in particular. The file in front of me was already memorized: petition, objection, affidavits, corporate documents, copies of my CPA license, letters from managing partners at 2 investment firms confirming my advisory role in multi-million-dollar restructurings. Documentation wasn't my shield. It was my mirror. When the bailiff called the case, my last name sounded unfamiliar in that setting. Whitcomb. Petition for appointment of guardian for an adult. We stood. The courtroom itself felt colder than the hallway. Dark wood benches, the Arizona state seal mounted behind the bench, fluorescent lights humming faintly overhead. I could smell paper-old files, new printouts, something dry and official. Judge Miriam Callahan entered without theatrics. She reviewed the docket, adjusted her glasses, and looked first at my parents' attorney. "Counsel," she said evenly, "you may proceed." Trent Halverson stepped forward with measured confidence. He spoke in the tone attorneys use when they believe the structure of their argument is sufficient to carry the weight of the accusation. "Your Honor, this petition concerns serious concerns regarding Ms. Alara Whitcomb's mental stability and capacity to manage substantial financial interests. Over the past year, she has exhibited erratic behavior, paranoia regarding routine business transactions, and impaired judgment that jeopardizes not only her own financial well-being, but that of a family enterprise employing dozens of Arizona residents. Erratic, paranoia, impaired judgment." He referenced emails I had sent questioning leverage ratios and vendor conflicts. He described my objections to share dilution as obsessive interference. He suggested that my refusal to cooperate with recapitalization efforts indicated an inability to appreciate strategic necessity. Then my father asked to speak. It wasn't required. It wasn't strategic. It was emotional. "She is not well," he said, voice louder than necessary in the controlled space. "She's been unstable since she was a teenager. She fixates. She lashes out. She doesn't understand the consequences of her actions. She is an embarrassment to this family." There it was. Not concern, not sorrow. Embarrassment. I kept my hands folded. My pulse was steady. Years of being described in rooms I wasn't meant to hear had prepared me for this moment. If I reacted, I would reinforce their narrative. If I remained calm, I would contradict it. Judge Callahan let the silence stretch longer than comfortable. "Mr. Whitcomb," she said at last, "this court requires evidence, not adjectives." A faint shift moved through the room. Halverson pivoted quickly. "Your Honor, we have documented communications demonstrating irrational escalation. We also have testimony regarding mood instability." "Any medical diagnosis?" the judge asked. "No formal diagnosis, Your Honor, but any prior psychiatric hospitalization?" "No." "Any documented cognitive impairment?" "No, Your Honor." However, she raised a hand slightly. The movement was small, but it stopped him mid-sentence. "This court appointed Dr. Lucas Kincaid to conduct an independent evaluation," she said. "His report has been submitted under seal. Before I review that on the record, I have a question." Her eyes moved from the file to my father. "Mr. Whitcomb," she said, leaning forward slightly, "are you aware of your daughter's current professional licensure?" There was a pause. My father glanced at his attorney. It was subtle but unmistakable. "She studied accounting," he said cautiously. "That was not my question." Silence again. Judge Callahan adjusted the papers in front of her. "Are you aware that Ms. Whitcomb is a licensed certified public accountant in the state of Arizona?" My father's jaw tightened. "I know she took some exams. She passed all 4 sections on her first attempt." The judge continued evenly. "She maintains active licensure and continuing education compliance." Halverson's posture shifted, slightly less upright, slightly less certain. "Are you aware," the judge continued, "that Ms. Whitcomb has served as a financial consultant in federal bankruptcy proceedings and has been accepted by a federal court as an expert in restructuring analysis?" The air in the courtroom felt thinner. My father didn't answer immediately. When he did, his voice had lost its earlier force. "I wasn't informed of that." The judge's gaze sharpened. "You are petitioning this court to declare your daughter mentally incompetent," she said, each word measured, "yet you are unaware of her professional qualifications and court-recognized expertise." No one spoke. I could hear the faint buzz of the overhead lights, the scratch of someone shifting on a bench behind us. Judge Callahan opened the sealed report. She read silently for nearly a full minute. It felt longer. Then she looked up. "Dr. Kincaid finds no evidence of cognitive impairment, mood disorder, or compromised executive functioning," she said. "In fact, he describes Ms. Whitcomb's analytical reasoning as exceptionally strong and notes that her concerns regarding financial structuring were technically sound." There was a visible change in the room. Not dramatic, not explosive, just a recalibration. My father's earlier certainty dissolved into something more fragile. The judge leaned forward again, elbows resting lightly on the bench. "Mr. Whitcomb," she asked quietly, "do you actually know who your daughter is?" And for the first time since this began, he didn't have an answer. The silence after the judge's question didn't feel accidental. It felt deliberate. Judge Callahan let it expand, not out of drama, but out of expectation. The burden wasn't on me to prove I was competent anymore. It had shifted. Halverson attempted recovery first. "Your Honor, competency in a technical field does not preclude emotional instability in high-stakes family contexts." It was a careful sentence, designed to pivot. The judge didn't look at him. She looked at the report again. "Dr. Kincaid conducted standardized cognitive testing, executive functioning assessments, and clinical interviews," she said evenly. "He specifically evaluated for delusional thinking, impaired judgment, and emotional dysregulation. His findings are unambiguous." She closed the folder softly. "This court finds no basis for temporary or permanent guardianship under Arizona Revised Statutes, Section 14-5, 303. It should have ended there. Petition denied, autonomy preserved. But it didn't. My attorney stood. Your Honor, with the court's permission, we would like to submit supplemental documentation relevant to the petitioner's stated motivations. Judge Callahan nodded once. The email thread labeled Capacity Strategy was handed to the clerk and then to the bench. I didn't look at my parents while she read it. I didn't need to. The shift in her expression was subtle, but it was there. The tightening around her mouth. The way her eyes slowed over certain lines. She read portions aloud. If Alara continues obstructing the recapitalization, we may need to explore incapacity proceedings. Temporary guardianship would neutralize voting complications. The word neutralize hung in the room like something chemical. Halverson stepped forward quickly. Your Honor, that language was speculative and taken out of context, counsel. The judge interrupted, calm but firm. This appears to be a discussion of using guardianship as a strategic mechanism in a corporate dispute. It was never implemented for that purpose, he replied. It was filed, she said. No one moved. Judge Callahan turned her attention directly to my father. Mr. Whitcomb, is this your email? Yes, he said, voice lower now. And by neutralize voting complications. You were referring to your daughter's 34% shareholder interest. He hesitated just long enough for the truth to become visible. Yes. The courtroom didn't erupt. There were no gasps. But something fundamental shifted. The narrative they had built that this was about my well-being fractured under its own documentation. Guardianship law in Arizona exists to protect adults who cannot protect themselves. It is not a tool to resolve disagreements over refinancing structures. It is not leverage in a recapitalization dispute. And judges know that. Judge Callahan leaned back slightly in her chair. The misuse of guardianship petitions for financial advantage, she said, measured and precise, raises serious concerns. This court does not take lightly the filing of allegations that could permanently affect an individual's civil rights and professional reputation. She looked at my father again. Do you understand the gravity of requesting that this court declare your daughter mentally incompetent? He nodded, but the confidence was gone. My mother finally spoke. We were trying to protect the company, she said softly. Not protect me. Protect the company. Judge Callahan's expression didn't change. This court's obligation is not to corporate continuity, she replied. It is to legal standards. She issued her ruling clearly. For the record, petition for guardianship denied in full. No temporary authority granted. No restrictions imposed. Costs and reasonable attorney's fees to be considered upon motion. Then she added something that wasn't legally required, but felt intentional. Ms. Whitcomb, she said, turning to me for the first time directly, the court finds you fully competent to manage your affairs. Fully competent. It was such a simple phrase. But after months of being described as unstable, erratic, unwell, it felt like oxygen. I didn't smile. I didn't nod triumphantly. I simply said, "Thank you, Your Honor." Across the aisle, my father looked smaller than I remembered. Not physically, structurally, like something foundational had shifted beneath him. He had walked into that courtroom believing he could define me. Instead, everything he had written, everything he had implied, was now part of a public record that reflected something else entirely. Not my instability, his intent. And once something is on the record, it doesn't disappear. The ruling didn't explode outward. It settled. That afternoon, the official minute entry was posted to the public docket: petition denied. No finding of incapacity, no guardianship imposed. For most people, it would have been a procedural conclusion. For my parents, it was something else entirely. Guardianship filings in Arizona are court records. Investors have attorneys. Attorneys read dockets. Within 48 hours, one of Whitcomb Holdings' minority lenders requested clarification regarding recent litigation involving principal shareholders. The phrasing was polite. The concern was not. Another email followed from a private equity group that had been in preliminary talks regarding the Flagstaff refinancing. They wanted reassurance that there was no internal governance instability. Governance instability. My father had tried to label me unstable. Now the instability had a different address. I didn't contact any of them. I didn't need to. The ruling spoke clearly, fully competent, petition denied. But the existence of the petition, especially the email thread entered into the record, created something far more difficult to control: doubt. My attorney filed a motion for reimbursement of legal fees, citing the lack of evidentiary basis and the documented strategic intent behind the petition. Under Arizona law, courts may allocate fees when proceedings are initiated in bad faith. We didn't argue emotion, we argued misuse of process. 2 weeks later, the judge granted partial reimbursement. It wasn't financially devastating for my parents. The Whitcombs were still wealthy. But it was symbolic. A court-ordered acknowledgement that the petition had crossed a line. Social consequences moved more quietly. My mother stepped down from one of her nonprofit board positions, citing personal matters. Invitations to certain fundraising events stopped arriving. Not dramatically, just gradually. Reputation in Scottsdale doesn't collapse overnight. It erodes through conversations at country clubs and golf courses, through careful distancing. At a quarterly shareholder meeting held a month after the hearing, I attended in person for the first time since the litigation began. The conference room smelled faintly of coffee and carpet cleaner. Floor-to-ceiling windows overlooked a manicured courtyard. The setting was controlled, familiar. My father avoided eye contact. When financial projections were presented, I asked questions the same way I always had. Calmly, specifically, without accusation. No one called me erratic this time. No one suggested I was overreacting, because now there was a court ruling behind my presence. The proposed preferred share issuance was withdrawn pending further review. The recapitalization timeline was extended. Officially, it was a strategic adjustment in response to market conditions. Unofficially, the leverage dynamic had changed. I didn't push for control. I didn't attempt to remove my father. That wasn't my objective. I maintained my 34% voting stake and my inspection rights. Nothing more. Nothing less. The greatest shift wasn't financial. It was relational. My parents stopped framing disagreements as evidence of instability. They stopped suggesting therapy as a prerequisite for involvement. Communication became formal, documented, cautious. There were no apologies. We didn't sit down for a healing conversation about boundaries. We didn't unpack childhood narratives or re-examine family myths. That kind of resolution exists in movies, not in boardrooms. Instead, there was distance. At home, my condo felt quieter than before. Not lonely, just uncluttered. I rearranged my living room one Sunday afternoon, moving the armchair closer to the window. I opened the balcony door and let warm desert air drift inside. The city below continued as it always had: traffic, distant sirens, late-night laughter from nearby restaurants. I realized something then. For years, I had tried to prove to my parents that I was stable, capable, rational, worth trusting. The courtroom didn't change who I was. It changed who had the authority to define me. And once that authority shifted from family narrative to documented fact, something fundamental loosened inside me. They had attempted to take my autonomy through the language of protection. In the end, they lost influence through the language of record. And records, unlike reputations, don't fade with gossip. There's a difference between being protected and being controlled. I didn't fully understand that until I saw my name typed into a guardianship petition, as if I were incapable of tying my own shoes. For years, I mistook my parents' scrutiny for concern. I told myself their criticism meant they expected more from me, that their constant monitoring was a form of investment. It wasn't. It was containment. When you grow up being described as too emotional or too intense, you start adjusting yourself to avoid triggering that label. You lower your voice. You soften your objections. You rehearse your tone before you speak. I did that for most of my 20s. I measured every sentence in board meetings. I filtered every email twice before sending it. Not because I doubted the numbers, but because I didn't want to be called unstable again. The strange part is that restraint can look like weakness from the outside. Silence can look like uncertainty. But in that courtroom, silence was discipline. It forced the focus onto evidence instead of personality, onto documentation instead of dynamics. What I learned wasn't about law. It was about narrative authority. My parents believed that if they repeated something often enough, sensitive, erratic, dramatic, it would solidify into fact. And for a long time inside our house, it did. The smell of my mother's perfume at dinner, the clink of silverware, the low hum of my father's voice explaining why I was overreacting those details, built a world where I was always slightly off balance. But courts don't operate on tone. They operate on standards. Clear and convincing evidence. That phrase stayed with me long after the hearing ended. Clear and convincing. Not emotional, not persuasive, not dominant, clear. There is a kind of peace that comes from realizing you don't need everyone to understand you. You need the right systems to function correctly. The probate statute functioned consistent. And the deeper lesson wasn't consistent. And the deeper lesson wasn't about defeating my parents. It was about detaching my identity from their description of me. They may always see me as difficult, as inconvenient, as someone who challenged their authority. That doesn't change the record. It doesn't change my licensure. It doesn't change my capacity. It also doesn't require reconciliation. People often ask whether I forgave them. The honest answer is more practical than emotional. I adjusted my boundaries. I moved conversations into writing. I stopped seeking validation from the same source that tried to revoke my autonomy. Forgiveness, if it comes, is quiet. It doesn't restore access. What the courtroom gave me wasn't revenge. It was clarity. I am not unstable because I ask questions. I am not irrational because I protect my stake. I am not dramatic because I refuse dilution. Sometimes the most radical thing you can do in a family system is remain steady. Not explosive, not vindictive, just steady. And once you learn how to hold that line without apology, the need to prove yourself begins to dissolve. When my father called me an embarrassment, he thought that was the worst thing I could be. What hurt more wasn't the word. It was realizing he truly didn't know me. The courtroom didn't give me revenge. It gave me recognition. A judge looked at the record and said clearly, "You are fully competent." That sentence didn't just protect my rights. It restored my name. If you've ever been misjudged by your own family, if you've ever had to sit still while someone tried to rewrite who you are, this story is for you. Subscribe if you believe strength isn't loud, it's documented. And tell me, if someone asked your parents who you really are, would they answer correctly?